Dear learners, hope you are having a wonderful time. Welcome back. We are having a discussion on the issues in digital marketing, and very specifically we are talking about the legal issues. So, if you remember, in the last lecture also we discussed about the various legal issues. We talked about the various legal frameworks that govern the various aspects of digital marketing, the environment in which digital marketing are being conducted, that is social media, internet, technology, information technology, all those things are very much are under the purview of the rules and regulation. When we talked about data privacy and data security, we talked about one act, that is Digital Personal Data Protection Act, and we tried to introduce the law, and we have had a very small discussion on this. But this act being the contemporary, it was only passed in August 23, and this is something which is a very new law, and even the mechanisms and all those things are still yet to come, but still this is the act which is something which is very contemporary, which is something which is very robust, something which is very stringent. So, I thought it is fair, or it is good that we should have an understanding of this particular act that governs the whole procedures, that governs the whole process, that governs the whole activities being undertaken by the digital marketer. So, today we are going to discuss the various highlights, the various aspects of DPDP Act 2023. Guys, this lecture is going to be very unique in the terms that we are specifically going to talk about this particular act. We are going to discuss specifically the wordings of the law. So, I tried to take information directly from the act which is being published in the form of gazette, and also I tried to take information from the big fours. So, this is going to be a theoretical rather, and but it is going to be interesting, because this is something which is going to influence even us, the users of internet, the users of social media. So, this is something which is for everyone to understand, and especially the youngsters who are very much active on social media, on internet, on shopping online. So, they should have an understanding, a basic understanding at least, about this act. So, let us have more clarity, more discussion on this act. So, we know that data privacy and data security is always a big concern for consumers, businesses or government alike. So, in the era of digital revolution, when India is set to establish as a digital economy, the pivotal role of data, its collection, its usage, its disclosure, it cannot be denied. So, if India have to move towards digital economy, if India has to grow, develop as a digital powerhouse, then it has to deal with the data. That is why it becomes very pertinent for India to have its own act, its own law regarding Digital Personal Data Protection Act. So, it should have act, it should have rules and specific rules and regulation regarding data privacy and data security, right. So, the policies of any nation are framed based on the insights developed from data. So, if we are going to frame any policy, the policy makers, they take cue from the data, they take various insights from the data. Even all the business decisions, they are primarily now based on data. So, the businesses, their decision makings, they are not made on the basis of intuition, on the basis of rule of thumb. So, gone are the days when it were used intuition and all those things were used. Now, we have various sophisticated statistical techniques, we have various tools which does various calculations, and now we are in a position to understand the data, to take information out of data, right. So, that is why now the decisions are more informed, and decisions are based on the information generated through the data. So that is why data is everywhere, whether it is a business, whether it is a policy maker or even the individuals. So that is why when everywhere we have data, and data are so volatile and it is prone to be misutilized or exploited, it becomes very pertinent for any country to have its own Data Privacy and Data Security Act, something like DPDP Act 2023. So digital marketers, they also take the leverage of consumers' data. So they also take the informations and insights from the consumers' data in framing various marketing campaigns. So the consumers are segmented and targeted based on various bases that are formed using the data analysis. So these data analytics, so in the probably in the next week we will also discuss about digital marketing analytics. So where we will emphasize that how these data are being used, how the consumers data are being used to generate insights which are going to help us in framing the marketing campaigns. So since the companies, the digital marketers, they are also taking various information from the data, they are also collecting, storing, analyzing, transforming the data. This rule, this law is also applicable for those people, also the marketers. Sometimes what happens, the businesses, they cross line in their marketing activities such as spamming, unsolicited calls or mishandlings of sensitive data of consumers. So what happens in the run of competition, in the days of cutthroat competition, what is happening, the companies, they sometimes cross their line and they go beyond their scope, and they try to exploit, they try to misuse the data. So therefore there is a need of law such as DPDP Act 2023. So let us have a discussion on this. Let us see what this act has. So Digital Personal Data Protection Act 2023, commonly known as the Privacy Law, Data Protection Law, it got assent approval from the Honorable President on August 11, 2023. So this landmark legislation focuses on ensuring the accountability in handling the digital personal data and also emphasizing the importance of explicit and transparent consent. So there should be explicit and transparent consent for data collection, processing and storage. So there should be a proper system of taking the consent, and that particular consent, that should be explicit. There should not be any hidden or something like that. It should be properly expressed and it should be also transparent. So that act, it also represents a paradigm shift that will redefine how the businesses operate by introducing stringent data protection and privacy measures that align seamlessly with the global standards. So now this DPDP Act of 2023, this is something which will take care of data protection and privacy, and it also aligns seamlessly with the global standards. So let us have an understanding and overview of this particular act. So this is the gadget, this is the first page of the gadget. I have just taken it from the site. So as a timeline, this is something which I have also discussed in the previous class, that in August 2017, Honorable Supreme Court of India, it declared right to privacy as the fundamental right. So then right to privacy came as the fundamental right, and it took almost 6 years. In the meantime, various various committees were found and they submitted various bills, there were discussions. So it took almost 6 years. On 7th August 2023, the Digital Personal Data Protection Bill was passed by the Lok Sabha. Then on 9th August, it was introduced and passed by Raj Sabha, the upper house of Parliament of India. And on 11th August 2023, Honorable President of India has given her assent to this particular bill, and thus it becomes Digital Personal Data Protection Act 2023. So, the application or applicability of the act, so it talks in two aspects. First is processing of digital and digitized personal data. So, processing of personal data within the territory of India or outside. So, whether it is being processed within the territory of India or outside, or any activity related to offering goods and services to data principals within India. So, the law, the act will not be applicable in processing for domestic or personal purpose by individuals or personal data being made public. So, it is not going to apply in these two conditions. There are few definitions that we should have understanding before we actually discuss the whole act. So, the consent manager, it means a person registered with the board. So, board here means the board regarding the data management. So, this act has also recommended to create a board. So, means a person registered with the board who acts as a single point of contact to enable the data principal. So, who is data principal? The users, to give, manage, review and withdraw her consent through an accessible, transparent and interoperable platform. So, the board, the consent manager would be a liaison, he would be the contact person to whom the data principal will give her consent, manage the data principal will manage the data, review the data and if she wants she can withdraw the data also. So, data here means representation of informations, facts, concept, opinions or instructions in a manner suitable for communication, interpretation and processing by human being or by automated means. So, all these Google Analytics, all this, so it will be applicable to those analytics as well. So, data fiduciary, this is something which is again one of the very stakeholder. So, consent manager. So, wherever it is capital letter, the first letter C D, so that means that is a person, data principal here, right. So, data fiduciary means any person who alone or in conjunction with other person determines the purpose and the means of processing the personal data. So, he is the one who is going to collect the data and he is the person who determines the purpose and the process of the personal data, and usually these are the managers of any company. A data principal means the individuals like you and I, the users, means the individuals to whom the personal data relates with. So, we are the one who are giving our information to the data fiduciary. So, digital office means an office that adopts an online mechanism wherein the proceedings from receipt of intimation or complaint or reference or directions or appeal as the case may be to the disposal thereof are conducted in online or digital mode. So, that is something called digital office. Similarly, digital personal data, it means personal data in the digital form. So, various demographic data, various opinions, perceptions, all those things will come under this. Personal data means any data about an individual who is identifiable by or in relation to such data, that is considered to be personal data. So, what is personal data breach? So, it means any unauthorized processing of personal data. Even unauthorized processing of personal data should be, and it would be considered as a personal data breach, or accidental disclosure, acquisition, sharing, use, alteration, destruction or loss of access to personal data that compromises the confidentiality, integrity and the availability of personal data is considered to be the personal data breach, right. So, these are the few definitions, they are not the exhaustive, there were many definitions provided in the act, but these were some which we are going to use in today's discussion, and they are the main, I would say, other key definitions. So, obligations of data fiduciary. So, when I say data fiduciary, it means the person who is going to take decisions regarding the data processing, probably the manager, the data manager of any company, or it could be the marketing manager also. So, engage with the data processor to process the personal data on its behalf through a valid contract only. So, there should be a valid contract. Provide a clear, concise and comprehensible notice to data principal. So, whenever there is the usage or there is any changes or there is any processing, it should inform the data principals. So, the data principals are basically the users. So, you have to provide them a clear, concise and comprehensible notice whenever there is some information, some notices are required to be informed to the users. Obtain verifiable parental consent before processing children's personal data. So, here children's means the child, also the minors. So, 18 years have been decided here. So, if the person, if you have to collect data from a user who is less than 18 years, then it should be by the guardian or the parent. Abstain from processing personal data that may cause harm to the children or undertake behavioral monitoring of the child or children or targeted advertisement directed at children. So, that should be, it should be, the company should abstain from, they should not do only, right, they should not try to process the personal data of children or undertake their behavioral monitoring. Implement technical and organizational measures to ensure effective adherence with the act. So, the company should have a system, they should build a system such that the technical and organizational measures, it ensures that they adhere to the act. Delete and cause its data processor to erase data as soon as the purpose is met. So, if the purpose is met, if the purpose is accomplished for which you have collected the data, then you should delete it. So, report personal data breach. So, whenever there is a personal data breach, it should be reported to the data protection board and the principals, that is data principals, that is users. So, both of them should be immediately informed about any data breach. So, there are other obligation for the significant data fiduciary. So, significant, when we say significant data fiduciary, so the act says that these data fiduciaries should be identified. So, anyone who collects the data are the data fiduciaries, but there are someone who should be termed as significant. So, how this would be defined, how the class of data fiduciaries as significant data fiduciary would be assessed. So, that would be assessed on the basis of some factors which have been pointed out here by the central government, and they will notify it that this is the process or this is the basis of the assessment. So, what are the various bases? The volume and sensitivity of personal data processed. So, if any company is processing high volume or high sensitive information, then it can be considered as SDF, right, significant data fiduciary. Similarly, risk to rights of data principal. So, the amount of risk to the rights, that ratio or that is being considered. Potential impact of sovereignty and integrity of India. So, if sovereignty and integrity of India, national security, all these are at stake, then again if a company deals with such data, then they should also be classified as SDF. Risk to electoral democracy. So, if you remember, I gave the example of Facebook Cambridge Analytica case. So, it was something which changed the whole face of US elections. So, if there is something which can risk the electoral democracy, then again those companies can be classified as SDF, and most of the social media platforms, they could be treated as the significant data fiduciaries. Also, if the security of the state is at stake, and if the public order, so law and order, if it is going to be harmed and it can cause the problem of law and order, then also that sort of company, that sort of fiduciary can be classified as significant data fiduciary. So, if you are classified as SDF, there are certain additional obligations that are levied on you. So, what are those? So, you need to appoint data protection officer who is supposed to be based in India, an Indian citizen. You should appoint an independent data auditor to carry out data audit. So, they should carry out data audit from time to time, and you should also undertake following other measures like periodic data protection impact assessment, periodic data audit, and other such measures which are inconsistent with the provisions of Act or as may be prescribed. So, moving ahead, there are certain rights and duties of data principals as well. So, it is also expected from the data principals that they should, though they have the right also, but they should also follow the duties which is being provisioned by this Act. So, there are primarily 4 rights which are being offered or which are being provisioned in this particular Act. Right to access information about personal data. So, whatever information, whatever data have been collected from you, you have every right as a data principal, you have a right to know or to access the information being collected by the data fiduciary. So, you have that right to access that information at any point of time. Also, you have right to correct and erasure of personal data. So, if you feel that this particular data is not correct, and you can ask for correction, and also if you feel that this should not be there in the data, though you might at one point of time have given the consent, but now you feel that this should not be kept with the company, then you can also, you have a right to get it erased. Also, right of grievance redressal. So, if you are having some grievance with any activity of data fiduciary, then you have every right to get your grievances redressed. This is again important, right to nominate. So, right to nominate can happen in 2 cases, like when if you attain some particular age, you can nominate, or even after death you can nominate. You can not after, obviously it is not possible. So, after that is in you nominate the person that after my death this particular person will have the right of the data related to me. So, sometimes it might happen that any person must have died and there are information related to it, but that does not mean that if the person has died that the data is free or it could be used or exploited in any way. But now this is a system where you can actually nominate any person, that even after your death that particular person will take care of the privacy or take care of security of your data, right. So, this is usually something which is applicable when you are a person of high demand, or if a person of national interest or something like that, even if though it is available to any citizen. A data principal shall perform the following duties. So, there are certain duties apart from these 4 rights, there are certain duties that is expected from the data principal. So, what are those duties? Comply with the provisions of all applicable laws for the time being enforced while exercising the rights under the provisions of this Act. So, if you are taking the privilege of various rights, then you should comply with the provisions of these laws as well. So, also you need to ensure not to impersonate any other person while providing your data for any specified person. So, if you are providing your data, you should not impersonate any person, you should not give a wrong person, or you should not copy, or you should not impersonate any other person. To ensure not to suppress any material information while providing personal data like document, unique identifier, proof of identity, proof of address issued by the state or any institution. So, what happens sometimes you provide misinformation or wrong information. So, providing wrong information again is not correct. So, either you have the opportunity not to provide the information, but if you want to take privilege of something, then probably there are mandatory things that you have to provide the information, right. But if it is asked, then you should provide the correct material information, and you should not play with the data, you should not provide wrongful data. To ensure not to registered as a false or frivolous grievance or complaint. So, you should not enter or register any false or bogus grievances with the data fiduciary or the board. Also, to furnish only such information as is verifiable authentic while exercising the right to correction or erasure under the provision of this act. Moving ahead, I was talking about the board. So, this is the board I was talking about, Data Protection Board of India. So, DPDP Act 2023, it has provision to establish for the purpose of this act a board to be called as Data Protection Board of India. So, the board will be a body corporate with separate legal entity, perpetual succession and all those things, and it should have the headquarter of the board shall be at a place as pleased by the central government or by its notification. It also talks about the composition and qualification for the appointment of chairperson and members. So, the board must have members, and there should also be they should have a chairperson. So, this act, it talks about the composition, what should be the composition of the board, what should be the qualifications of the members or the chairperson, what should be the salary and allowances payable to them, what would be the term of their office, also what are the various disqualifications for appointment and continuation as chairperson or member of the board. So, both qualification and disqualifications have been laid down. So, what is the process of resignation by member, and also when there is a vacancy, how it is going to be filled, what would be the various systems of the proceedings of the board. So, all those things have been highlighted in this act. Also, the board is entrusted with the task of enforcement, including determining non-compliance, imposing penalties, issuing directions and mediation to resolve dispute between the parties, and to ensure compliance with the law. So, the board is responsible for handling these issues, whether it is the issue of non-compliance, whether it is issue of imposing the penalties, whether it is about mediation between the two parties, or whether to ensure the compliance of the law. The board will be entrusted with this task. The board is enshrined with the powers of a civil court, and appeals against its decision lie to the Telecom Dispute Settlement and Appellate Tribunal also. So, the last, it talks about the personal data breach and the various penalties. So, there could be a chance of personal data breach also. A data fiduciary is required to protect the personal data of the data principals, including any processes being undertaken on the behalf of the data processor, or by taking any reasonable security safeguard to prevent such personal data breach. So, the data fiduciary have twin role in the sense, on one side they should try to protect the personal data, and also on the other side they should build such infrastructure that facilitates the protection of personal data. So, however, there could be a chance that there is a breach. So, in case there is a personal data breach, then the data fiduciary needs to notify the board and each affected data principals of such breach. So, in case of personal breach, the fiduciary will immediately inform. However, the timeline has not yet been defined, but it should inform the board as well as every affected data principals. And in case there is any non-compliance, then there is a provision for various penalties as well. So, in case there is a breach in the observance of duty of data principal, then up to 10,000 is the penalty. If there is a breach in the observance of additional obligation in relation to children, then up to 200 crore. Breach in not giving notices to personal data breach, up to 200 crore. Non-compliance of the provisions by the data fiduciary, up to 250 crore. So, you just imagine the quantum of the penalties. So, you can understand how stringent this law has been framed and very much needed also. So, if we are talking about data privacy, if we are talking about data security, then obviously we should have such law, and we as a Indian, as a country, we are proud that we are having such act known as DPDP Act 2023. So I tried to highlight the various aspects, various facets of this law. Hope I have tried to clear these things, and I hope you have understood the various aspects of this particular law. That is all from my side today. I hope you have enjoyed. Thank you so much. Have a wonderful time.